that imposition of expiatory fine in addition to incarceration would also serve the penological purpose of deterrence, having regard also to recidivism. Stop. It may also be noted that under section 304A of IPC, either imprisonment only or with fine or fine alone, is the prescribed punishment. Stop. Having regard to the wide discretion available to the court under section 304A, and having regard to the fact that the High Court and this court, in appeal, had limited the imprisonment to 1 year, in our view, the punishment which would serve deterrence and public purpose by both imprisonment and exemplary fine, would be an appropriate punishment in a case like this. Stop. Under section 63 of IPC, where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited, but should not be excessive. Stop. Having regard to the gravity of the offence and the illegal gains made by the accused, the fine imposed to the tune of rupees 60 crores is not excessive. Stop. However, there is no provision under the IPC for substitution of sentence by fine. Stop. The only provision is on default. Stop. These review petitions seek review of the orders of this court in criminal appeals. Stop para. Since arguments have been addressed only with regard to the sentence awarded to accused Sushil and Gopal Ansal, consideration in this order is confined to this aspect. Stop. The matters arise out of an incident dated 13/6/1997 of fire in Upahar Cinema, wherein 59 persons lost their life and about 100 persons were injured. Stop. On charge of criminal negligence, apart from others, accused first, the license for running the cinema, and his brother Gopal, who was in fact conducting the business of cinema, were convicted under sections 304A, 337, 338, read with section 36 IPC. Stop. The trial court sentenced them to undergo imprisonment up to 2 years, which was reduced by the High Court to 1 year. Stop. It was submitted that the default sentence cannot exceed 1/4 of the term of imprisonment prescribed for the offence. Stop. It was also submitted that undue sympathy in imposing inadequate sentence may lead to miscarriage of justice. Stop. There should be element of fear in the mind of offender for which adequate sentence was required to be imposed. Stop. It was also submitted that sentence prescribed under section 304A IPC was required to be revisited by the lawmakers in light of observation of this court. Stop para. Judgments to which detailed reference does not appear to be necessary, as there is no dispute about the principle that adequate sentence as warranted in a fact situation has to be awarded by a court. Stop. Opposing the above submissions, learned counsel for both the accused submitted that there is no patent error which may justify invocation of review jurisdiction. Stop. The arguments now sought to be raised were before the court when the order was passed by this court. Stop. The review petition cannot be treated as an appeal in disguise. Stop. Mere possibility of two views cannot be a ground for review. Stop. Reference was also made to several decisions of this court, where long delay in pendency of proceedings, age, health and other factors have been taken into account for awarding sentence lesser than the maximum prescribed. Stop. It is not necessary to refer to the said decisions also, as it is well settled that the sentence has to be awarded in the light of nature of offense, prescribed sentence, over all fact, situation, mitigating and aggravating circumstances, including age of the offender, his background, possibility of return to normal life and need of the society. Stop. In support of these submissions, reference has been made to several. Stop.